session. So I hope I will not let you all to sleep. I will just keep you awake and I'll also ask questions in between. So rather than you asking me questions, in fact, I'll ask you questions in between. So that just to check whether you all are awake or not. Just that on a lighter side. As I know that this is a workshop and you have already had a session yesterday uh, for the introduction part for the MSME Act, you have already understood. Um, can anyone brief me what all you have understood till now? Maybe you can just unmute yourself and you can speak up. We have just 14, 15 participants, so I think it can be a very good interactive session. Action recap, anyone?
Yes, we have been gone through the most relevant section of MSME,
Yes,
starting
sir.
from that applicability and section of 18(7), and there was certain arbitration matter was also linked with this, how this arbitration and these two acts are similar in the nature of so far as conciliation is concerned. And we were cited a few case laws. Most important question was whether interest portion should be treated as a claim in getting the threshold limit of 1 crore in order to initiate action in IBC.
Right. So what was the answer for that?
No, interest portion is not applicable if there is no specific agreement.
Right. And normally there is no agreement in MSMEs.
There is no agreement.
Right. Very well said, Rajma sir. I know you were very much active yesterday. Even I was attending the sessions and you were asking most of the questions.
Thank you
So
so much, ma'am.
today I would request everyone to be super active, not just Rajkumar sir. I would like you all to participate. Just to add upon what sir has said, like in MSMED, that is the act of governing the MSMEs. This was framed way back in 2006. However, all the provisions were already there. There is nothing, there is no change or there is no amendment in that particular act. But nowadays, you might be hearing that in Income Tax Act, recently they have said that Section 43BH has been introduced, and it says that whatever payments are there, outstandings are there for MSMEs, they will not be allowed from this financial year itself. So thereby it is actually supplementing whatever was mentioned in the MSME Act, because MSME Act was not being taken care by many people. It was not having very much penal provision, so people were not actually concerned about it. So now it has been collaborated, I would say, with the Income Tax Act itself. So whosoever is now dealing with MSMEs, they have to be more conscious, and therefore there at the end of their balance sheet, there should not be any outstanding portion of this MSME within 45 days. The 45 days time limit, as you all might have read or studied yesterday, that within 45 days the payment has to be made, even if there is no specific agreement for that. So 15
So
days criteria is also there.
ma'am, this
Yeah.
is applicable for the financial, this is a particular section which has been changed in Income Tax Act, which is applicable for financial year
So for this
2024-25.
year also, this while you will be filing the returns for this financial year 23-24, it is applicable for that also.
Okay.
Okay. So let me just know how many of you are actually practicing as an insolvency professional. Can you just mention that in chat? If you're practicing as an IP, then please mention yes, or you can simply write Y, so that I actually know that you just have a theoretical knowledge or you are actually doing something in that field. Okay, Chetna ma'am has written that yes, she is doing something in that field. Anyone else who's practicing as an insolvency professional who has handled any cases on his or her own or maybe assisted someone? There is no one?
Ma'am, actually, I'm also practicing as a in IBC in the capacity of from different position, but I'm unable to, make the mentioning in chat box.
Is the chat box not allowing you to reply anything?
Yes.
Okay. The technical team of CS Institute, please take care of it. The participants can write in chat box or not. Please take care of it because I'll be asking questions, so they will have to respond either verbally or maybe in the chat box.
Yeah, it has started now.
It has started. Okay.
I think, yeah.
Okay. Okay. So two people are practicing. Chetna ma'am and Rajkumar sir. Anyone else? Okay, let it be. Even if you are not practicing, I think you are thorough with this particular topic. Anyone who has cleared before the pre-package plan came into, that is PPIRP, has anyone cleared before that period also? I mean, before 2021, has anyone cleared? Okay. So because all those who have cleared post 2021, they are aware that this is a scenario of PPIRP. Okay. Chetna ma'am has cleared in 2017. Great. So you are very senior ma'am. We'll be asking any doubts which we have, then we will be asking you in that case. Okay, ma'am, have you handled any MSME case? I would like to know from you then. You can unmute yourself and you can reply.
Yes, currently I am handling one MSME
Okay, ma'am, you are based at which
in
place?
in Mumbai.
In Mumbai itself. Okay. And what is the case? Can you discuss with us?
Yeah, it is a real estate company,
Okay.
and like the project is over, but there was a default, and operational creditor
And
has
the default amount was?
default amount was I think two 2.5 crore.
2.5 crores. Okay.
It was by your operational creditor.
By operational creditor.
Creditor.
Fine.
Yeah.
Fine. And this, the corporate debtor which we are talking about is micro, small or medium? Which category?
Micro.
Micro. Okay. And what did you suggest? You asked them to file under this CIRP only, right?
Yeah, because it had already been filed. I was appointed by NCLT as resolution professional, not as IRP.
Okay.
Yeah.
Okay.
Yeah.
So I think you might be having a little bit of idea. Other people, I'm talking to everyone now.
Yeah.
That whenever a client comes to you, firstly, what should you analyze? You should ask him or her what is the scenario, whether the person is a corporate operational creator or a financial creator. I think you all are aware what is the difference. And then you have to study about the corporate debtor as well, whether that falls under the category of micro, small, or medium. Then we will have a separate scenario. And if the person is not falling in the MSME, then we may have a different scenario. Okay, can anyone tell me this PPIRP, which we will be talking about today? This is actually the full form is pre-packaged insolvency resolution process. So can application be filed under PPIRP or CIRP or both? Can we file application in both the scenarios in PPIRP if corporate debtor is MSME, right? So is it that we have to compulsorily file it in PPIRP, or we can file it in CIRP, or we
Yeah,
can file it in both?
yeah, in any of the one you can file, and PPIRP you should have a resolution applicant ready, right? Yeah. So
Right.
in any other like section 10, the option will be open that anyone can bid. Right.
Right. So in section 10 also we are seeing that uh, the corporate debtor itself is filing an application for insolvency resolution process. And similarly in PPIRP also we'll see that promoters of the company are filing a case. But how these two are different process that we will be studying today. So before directly jumping into what is PPIRP, I'll first take you through the definition of MSME and then how the proceedings have taken care till now? I mean, what was the scenario? What is the history about incorporating this kind of process? And we'll be discussing a little bit of about it, and then we will see a detailed uh, uh, scenario about the PPIRP process. Before jumping into that directly, just let me know how many PPIRP cases have been filed so far. Any idea? Have you ever heard
6 or
about any
6,
application?
yes, 6 or 7.
Very less, in fact. Yeah, six, more than 6, 7, but yes, it is very, very less. In a year, hardly 5 or 6 applications are filed. So, till now, how many have been filed? We will be discussing the statistics also. And what is the reason why there are so less applications filed in PPIR? What is the process? Why it is not gearing up? So, that is what also we will be discussing. The basic thing is in CIRP, the threshold limit is 1 crore. The default should be 1 crore. However, in PPIRP, we say that even if the default is 10 lakhs also, you can file a case directly in PPIRP. So that is the basic difference. So if someone has defaulted, but the amount is lesser than 1 crore and that person is falling under the category of MSME, then you can straight away go and file this PPIRP application. One more thing, if you do not want to go into this insolvency proceedings under MSME, like yesterday you have already studied about it, you can directly go to MSME Act, and there the facilitation council is there. You can file an application that a person is not has not paid, and even you can get the interest there. So that is a less time consuming process as compared to the insolvency, I would say. So though both the possibilities are there, wherever you want, you can file. But nowadays, mostly people are going to that MSME Facilitation Council. It is basically known as Samadhan Portal. If you have heard about it, it is Samadhan Portal of the government. You can directly Google it, and you will find the details how you have to apply and how you can take the things into the court. So,
Madam, this threshold is 10 lakhs only, right?
yes, sir. Yes, sir.
Invoking
Yes,
in
sir.
IBC under
Yes,
PPIR.
yes, yes, sir. So
And
we'll be
that,
taking all the details, sir. We will be taking all the details just to make a difference. What is just to make out the difference? What is there? What is unique about this PPIRPs? Even if you are having lesser amount of default, you can still file an application under IBC, and that is how it was designed.
lesser
Overall.
amount you mean to say, because the threshold is 10 lakh. So how
Threshold
can
is
like
10
it?
lakh.
Yes, 10 lakh. So
Yes,
like it should be over and above 10 lakhs, not below that, na?
of course, sir. Of course, minimum 10 lakhs.
Minimum 10. And it has to be
Minimum.
filed under section 10.
No, sir. That we will be studying now.
Okay.
Okay. I'll just share the screen. Just let me know if it is visible to you. Just a sec. Is my screen visible? Yes, ma'am. Okay, great. So let us first understand what all topics we will be discussing today. So first is what is MSME? This you already know, but I'll be just quickly running you through. Then what are the reasons for insolvency of MSME? Normally, the for others, for everyone, I would say, what is the reason of insolvency? Uh, so that we'll be discussing in somewhat in a quicker fashion, because it is just a simple question. Why do MSME become insolvent? Then what are the international practices regarding this MSME sector? How do they resolve in other countries? Then what is the insolvency resolution process for non-corporate MSMEs? Then next topic is insolvency law committee report relating to MSME. What is the governing framework, that is PIRP, how it is governed overall? What is the background and key feature of PPIRP? What is the difference between CIRP and PPIRP? What are the relevant sections? What is the eligibility criteria? What is the checklist before filing? What should you take care of? All that we will be studying. Then there is one more keyword which will be used again and again, that is BRP, that is base resolution plan, which you have not used in CIRP basically. It is used here only. So ultimately, finally, what is the overall workflow of this PPIRP? We will be studying in detail. Then what are the various list of forms that should be filed? What is the timeline? What is the role of insolvency professional in all of this? And then finally, some case laws which we will be discussing. So let us start with this section 7. You have studied some definitions yesterday. You have talked about, you have already discussed in detail about this classification criteria, MSME. So it is basically micro, small, and medium. Micro, what is the investment in plant and machinery or equipment? It says that it should not be more than 1 crore. So any organization which is having plant and machinery, or even if it is not having any plant and machinery, then also it is considered as a micro. And its annual turnover. See, the conditions are, I would say, both the conditions. This is cumulative condition. So both the conditions have to be satisfied. So your plant and machinery should not be more than 1 crore, as well as your annual turnover should not be more than 5 crore. Then only you will be considered as a micro. For small, the investment in plant and machinery or equipment should not be more than 10 crores and the annual turnover should not be more than 50 crores. Then an investment in plant and machinery or equipment should not be more than 50 crores and annual turnover should not be more than 250 crores. So just let us assume a scenario wherein a corporate debtor has investment in plant and machinery or equipment of around 2 crores, but its annual turnover is 3 crores. I repeat, a corporate debtor having an investment of plant and machinery of about 2 crores and the turnover is 3 crore. In which category it will fall? You can unmute and answer, please. Anybody?
Could you repeat your question?
The investment in plant and machinery is 2 crore and the turnover is 3 crore. In which category will the corporate debtor fall into?
Is it a small?
Okay, any other answers? Okay, the answer is correct. See, others also you need to reply even if it is wrong, because here we are there to study and you can simply reply by, unmuting yourself. It is a very close compact group. So need not to worry even if your answer is wrong. It's okay. So it is small category. The reason is
one question here.
yes, ma'am. Yes, ma'am.
Yeah, so even if it is micro or if it is small, well, it doesn't make a difference, right?
Right, ma'am. Right, ma'am. But when you are applying for some benefits in MSMED, there you have to be very specific, because for that facilitation council, which sir was talking about yesterday, it is only available for micro and small. It is not available to medium.
Okay. Yeah.
However, in IBC, they have not made any difference. They are simply saying that even if you are micro, small, or medium, anyone can go there. But at least we must know whether a person is falling in which category. And how do you come to know a person is falling in which category? You can simply ask them. You can see their financials, or there's one more thing where you can check. What is it? Any idea where you can check in
Yeah,
which,
that website, right? Udyog.
yeah, you can just ask them whether they are registered on
Registered.
MSME,
Yeah.
they have Udyam registration or
Huh.
not. If they have Udyam registration, on the Udyam registration itself, it is mentioned that they fall in which category, micro, small, or medium. So you need not to, it's not that the other person is saying and you are just blindly accepting whatever he's saying. You can also cross check it somewhere. So the best thing is you can take their Udyam registration and just cross verify whether the person is falling into that category or not. So micro, small, or medium. I'm just telling you this category because this classification is very important with respect to this MSMED Act. Because this PPIRP scheme is only for MSME. If a person is MSME, then only this PPIRP scheme will be applicable for that. Otherwise, it will not. And therefore, we are studying this. And there is an explanation also attached to it, what all you have to include or what you have to exclude while considering the investment in plant and machinery. So, like it is saying that it is clarified here that while calculating the investment in plant and machinery, cost of pollution control, research development, industrial safety devices, and such other items may be specified by notification shall be excluded. So normally, pollution control devices or the any equipment which is for pollution control, it is not counted as a part of your plant and machinery. So that is how the computation differs. So in short, we can say, or we can summarize in this fashion. Nowadays, even the for manufacturing as well as services, both the enterprises are having common criteria. Earlier, there were two different scenarios for manufacturing and service enterprises. However, now it is same for both of them. And even traders and wholesalers are included in this category. And just to add upon one thing, like sir yesterday mentioned that professionals cannot register themselves in as MSME. Um Sorry to say, but they can. MSME can. Professionals being a lawyer, doctor, or any chartered accountant or any other person can register themselves as MSME. They can have the benefit of MSME. It is very much clear now. So these are some key points which need to be considered while classifying into this category. Composite criteria is to be followed. That means both the limits have to be fulfilled. Only then they will be classified in that particular category. See why this has been emphasized more again and again, because in MSME Act, there are benefits which are related to micro. There are some micro specific benefits. There are some small scale benefits, small enterprises benefits. Some benefits are given to all the three, and some benefits are given to only micro and small. So again and again, you have to keep checking, and it also may vary year on year. So for this year, maybe an enterprise was considered as micro. Maybe next year they will jump into the category of small. So again and again, this classification will change. So that is why again and again it is being said that. So same limits are applicable for manufacturing as well as service, and it is applicable for manufacturing, service, wholesaler, retailer, everyone. So now everyone is into this ambit. Export of service or goods, both shall be excluded while calculating turnover. So this is very, very important. There are some enterprises, there are some entities which are dealing only in export of goods or services. So that is totally excluded while calculating turnover. So if they are only exporting and there is no domestic sales for them, so the sales will be considered zero and they are simply classified in uh, based on the investment in plant and machinery, they will be classified there. Okay, and here again it is said that investment in plant and machinery will be determined from your previously filed ITR. Like in income tax, you already know that we have to keep on filing the details of the fixed assets along with the depreciation thereon. So they have your data already. So based on that data only, investment will be classified. You cannot give two different values in income tax and MSME. Those have to be similar. That is
Suppose in some of the financial year, I'm not able to file my income tax return. Then can this, like, obtaining a certificate to this effect will do? Will
No, sir,
will
but what is
suffice?
the reason why you could not file? Because once you have started filing the returns, and it becomes mandatory to file the return. And next time, whenever you will be filing, so it will take your previous data, whatever previous data you
Okay.
had. So income tax department has a consolidated data of year on year for you. So based on that data, your classification will be done. And this classification can be changed also based on your new statistics or new criteria. So whenever you will be filing next return, it will be changed accordingly. Next, we have already dealt about the section 43BH. This has been recently amended just to give benefits to the MSME so that their working capital goes on smoothly. They do not face the hardship of funds with them. So therefore, this section was introduced. And finally, it is a very much awaited, it was a very welcoming step from the government side that they have introduced such thing in income tax. Though it has created a lot of chaos amongst bigger enterprises, but yes, it is a much relief for the MSME part.
So do you think this will uplift the filing of PPIRP? Because corporate debtor would be deterrent to, I mean, in order to forego the claim.
No, so everyone will be filing because it has a very severe tax penalties. 30% straight you will have to pay the tax. The whole amount of expenditure will be disallowed. So people have paid off their balances with MSME. Next is, what is the reason? What do you think? What are the reasons for this insolvency of MSME? I want you all to please mention in chat, or you maybe unmute yourself and then answer. So let us have an interactive session. What do you think? What are the reasons?
The reason, like, what this is my personal opinion, is that because just due to this COVID was that another, uh, another situation wherein, like, all these small scale industries were under stress. And if you see that there was something for the manufacturing, because see, this SME is the main feeder to the manufacturing company.
Right.
So the whole system was getting, there was a vicious cycle in that, and everybody was getting trapped just because of all this, because people were not taking care of, like, making the payment to small scale industries.
Right, sir. That is one of the reasons. Because of COVID, many people had to shut down their business. And therefore, at that point of time, in 2021, this particular amendment took place for this PPIR altogether. So let us, anyone else also who wants to share his or her views? What are the basic reasons of insolvency of any entity? Okay, let me be. So these are the basic reasons. Normally, MSMEs face a lot of cash flow. Anyone was saying something? Okay. So normally, as we all know that in business, cash transactions are very less, and mostly business run on credit transactions. So there are cash flow problems, and just to counter that, this Section 43BH is now introduced. Again, there is lack of access to finance because whenever the small enterprise go to bank for funds and loans, bank, they ask for collateral. So if they cannot provide good collateral, the bank refuse to provide any funds. So again, they face a lot of difficulty in, continuing their business because of lack of funds. Then again, there are high operating costs because of their low structure, and they cannot improve their technology very fast, and therefore they have a lot of operating cost also. Then again, there is a market competition. If a person is selling something at, suppose, at 10 rupees, and a bigger enterprise is selling the same, because of large scale production, they can sell it at maybe 8 or 7. So thereby the small enterprise will not be able to, handle the competition. It will not be able to survive the competition, and therefore they are bound to, close their businesses. Sometimes there is inadequate business planning and management. There is over reliance on key customers or suppliers. There is inefficient process and technology. Because again and again, you have to keep on, investing in technology to stand the competition, and they don't have funds to do that again and again. Then again, there are many regulatory compliances and bureaucratic hurdles, which nowadays is not so much, because there is a total new wave by Modi government. They have introduced many steps for Stand Up India and Atmanirbhar Bharat and things like that. So they have actually promoted MSME in all spheres. Economic downturns and market disruption, this is very relevant point for each and every business, so not just MSME, for any other business also this is a very relevant point. And then there are some personal factors also, because many enterprises, many entities are under sole proprietorship or partnerships. They might not continue the business because of their personal quarrels or any disagreements between the partners, or maybe if it is a sole proprietorship, it is a personal, the person himself has fallen sick, or he is not able to handle the pressure or anything like that. So these are the common reasons why any MSME goes into insolvency. What are the international practices? So let us understand how it is being dealt in other countries. We are just discussing the small businesses. Like insolvency laws are there in each and every country, but we are discussing only about the how they are dealing, especially with their small business enterprises. So, like in United States, it is called Chapter 11 bankruptcy. So, small businesses often file for Chapter 11 bankruptcy, which allows for reorganization of debts while the business continues to operate. So, it is not complete shutdown; it is just the reorganization of their debts. So, just like we call restructuring of the debts, it is just like that. So this is handled in this way in United States. Again, Small Business Reorganization Act is also there, which was introduced in 2019. This provides a faster and less expensive Chapter 11 bankruptcy process for small business with debts under a certain threshold. So they are not going into detail what is the threshold and everything. It is just like PPIRP in our case. They also have this kind of thing. Debtor in possession financing. So, okay, this is again a term which you need to understand. What do you mean by debtor in possession? Like in CIRP, we understand that creditor has gained the control. Now, the management loses the control as soon as the application is admitted in Section 7, 9, or 10. If the application is admitted, the management loses its control, and COC takes care of everything now, or the resolution professional, along with the advice of COC, it works. So, normally in CIRP, we say that creditor in control takes place. However, in PPIRP, we will be using the term debtor in possession. Debtor would mean just the corporate debtor. Debtor, that is the management, is still in the possession of the business. So same ways in United States also, they are using this term debtor in possession financing. Small businesses in Chapter 11 may obtain financing to fund operations during the restructuring process. So they might be needing interim finance or something like that. So they can go for this kind of thing, as it is said. Okay, then in next country, we are discussing in United Kingdom how it is dealt there. Uh, Small firms can enter administration, where an administrator takes control of the company to try to rescue it or achieve a better result for creditors than in liquidation. So altogether, a third party comes into, that is known as administrator. They will take control, just like RP, that person is here known as administrator, and they will search out the better option. This is how it is dealt. Then there is one more thing here, company voluntary arrangement. This allows a company to reach an agreement with the creditor to repay debts over a fixed period. So this company voluntary arrangement is a kind of out of court settlement. They are not going to court. They are mutually settling their dues amongst themselves. Then in Germany, how they take care of it, they have insolvency plan proceedings. This allows a debtor to propose a restructuring plan to creditors for approval. often used by small and medium-sized enterprise. Small business insolvency proceedings are also there. Then in Japan, they have their civil rehabilitation, just like Chapter 11 bankruptcy in US. And they have this simplified corporate reorganization procedures also, which was introduced in 2018. And they provide more streamlined process for small and medium sized enterprise to undergo. Similarly, in Australia also, they have this kind of structure. So what we are basically talking about is in each and every country, there is a separate structure or a separate form of law or anything like that is there for which is taking care of the small and medium enterprises, micro, small, and medium enterprises. In other countries, they might not be using this term MSME. They are using it as small business or small companies or things like that. But the process is similar to what other countries are having, and that therefore India has also imbibed this from these international practices that we should have some separate legislation for this MSME sector altogether.
So for this, like, which one is, is it a OTS or haircut, like, which is giving an edge in these countries?
So we will be discussing that also because why PPIRP is not gaining so much because of this OTS only. OTS is one-time settlement. People prefer more one-time settlement procedures rather than going into this court or tribunal matters, which is there in PPIRP. And therefore, it has not gained much value so far. That is the thing. So both the things are present in our country. Both the options are available here. However, PPIRP has not gained much because of this OTS. OTS is more preferred by the banks. I hope I have made myself clear, sir.
Yes.
Okay, next, this I would like to know from you. What is the insolvency resolution process for non-corporate MSMEs? As we all know that this whole IBC is designed into it is designed in 2-3 parts for corporates and for non-corporates. For corporates, we have CIRP. Then for non-corporates would include sole proprietorship, partnership. For them, what is the scenario? So for non-corporates, as we know, the code has not become active at all. It is still to be notified. So similarly, if there is any MSME, which is a non-corporate, so if any MSME is sole proprietorship or partnership, the law does not give anything for them. However, if they are corporate entities, it is still available in the form of CIRP or PPIR. This part is clear?
Yes.
I've not written anything, but it is just simple thing that you should understand that we are dealing only with corporate form of organization. For non-corporates, only personal guarantors are taken care, but not others. So this is again a background of PPIRP, this report of the Insolvency Law Committee 2018. There they mention what should be the scenario, how we should deal with MSMEs, what could be the procedure to be adopted by them. So all the law regarding PPIRP was discussed in this particular report. And broadly, they have come up with the fact that MSME promoters are not disqualified under Section 29A. This also you have studied yesterday that 29A section disqualifies basically the promoters and the other
sorry.
for specifically MSMEs, they have excluded the promoters of MSME. They can still go for the resolution plans. So they can still apply for the resolution plan. So it is also known as a backdoor entry. So you are the promoter of a particular company, but you cannot run it in good fashion. You are incurring losses, and your entity is incurring losses, and now you don't want to shut it down, but you want to have a resolution plan so that your liabilities are somewhat paid off after a huge year or something. You keep on continuing the control of the company. So it is just like a backdoor entry. The promoters can continue the business in the same fashion as they were doing earlier. So this is what it is basically in the case of PPIR. So what is there in the report? Why this report? It has made out some few key points of concern regarding MSME. So it is saying that MSME, which are usually operational creditors to such large businesses, are suffering in two ways. This is very important. Why MSMEs are suffering in two ways? Let us understand. First is temporary credit disruption created by large businesses being in CIRP is leading the affected MSMEs to be dragged into insolvency, which may potentially lead to liquidation. So let us understand this first point. Like if a large enterprise has gone into CIRP, suppose we just let's talk about Kingfisher Airlines, suppose. If it has gone into CIRP process, then if they had taken some services or goods from MSME, indirectly, those MSME will also be dragged into the trap of insolvency. So that is what this first point leads to. So indirectly, they are coming into this trap. Second point is, in a CIRP where MSMEs are operational creditors, the liquidations value guaranteed to them is very negligible. So even if they are paid in CIRP process, even if they become operational creditors, they are paid, but there is a huge haircut. So the amount paid is very negligible. So again, there is a shortage of funds for them to survive, and therefore it leads to insolvency for them again. MSMEs are the bedrock. So this is the statement which was given in the report, which is the heart of the PIRP. Why they want this PIRP is because of this. MSMEs are the bedrock of the Indian economy, and the intent is not to push them into liquidation and affect the livelihood of the employees and workers of MSMEs. The committee sought it to explicitly grant exemptions to corporate debtor, which are MSMEs, by permitting a promoter who is not a willful defaulter to bid for the MSME insolvency. So I think this paragraph will make it more clear why in section 29A, MSMEs promoters are not, they have been exempted from that particular section. It is not applicable to them. So it is just saying that for MSMEs, we are exempting the promoters. They can still file the resolution plan, provided they are not the willful defaulters. So if they are doing it willingly, they are really committing any kind of fraud. In that case, this will not help. But if it is a genuine case, then surely they can file a resolution plan and they can continue to be in possession. The
Madam,
rationale,
this defaulter should be continued as on date of CIRP?
yes, sir.
Okay.
Because normally the business, they show that the business is not going on, the entities running into losses. They show it like that, but it simply says that it is not paying. So on your records, you have so much defaults. You are not paying to persons. So it is being in a continued nature. So willful defaulter, they have been willfully not paying to the creditors. So this has to be proved. The rationale for this relaxation is that a business of an MSME attracts interest primarily from a promoter of an MSME and may not be of interest to other resolution applicants. This last paragraph clearly says that in case of MSMEs, if you continue with the CIRP process, you might not have enough resolution plans. In fact, you might not have even a single resolution plan from outsider, because others might not be interested in your company or that particular MSME. However, the promoters are still ready to take the business again. So that is why it is said that promoters have their interest still there. It might not be that the outsiders are looking forward to it, and therefore the promoter should be given a second chance by filing an resolution plan in this case. So again, this section 29A, it was discussed in the parliament. And then finally, I'm just reading the summary response. The committee has recommended that a provision in addition to section 240 of the code must be provided in order to enable government by way of notification, exempt or modify application of certain provisions related to MSME. So what does it say? It simply says that this is the core basically why this Section 240A or 240B was introduced. So it is relating to that. Central government now has the power to, it may exempt, or it may, whenever it wants, it may modify. So it has that power with respect to MSMEs. With that, they can use their powers by way of notification. They can issue rules or regulations. So then insertion of section 240, again, it was a kind of exemption for certain provisions of MSMEs. It basically, this type of thing you have already studied yesterday also. And just to recollect, these 2 points were made as an amendment in the code for MSMEs. So now we are going for pre-packaged insolvency resolution process for MSME, which is known as PPIRP in short, and it is specifically for MSMEs. So till now, are you able to grasp whatever we are dealing with? Can I continue?
Yes, very much.
Okay, sir. So let us understand what is the governing framework. So governing framework would mean what all you have to take into consideration, or what all you have to study before filing any application, or before going into practical aspects of PPIRP. So like you have to study the code, you have to study rules, regulations. So all that is taken care here only. So for PPIRP, where what data or what details you need to go through, that is what we are discussing. And for triggering PPIRP, where all it is mentioned. So that is what we are studying. So the IBC has amended by Insolvency and Bankruptcy Amendment Ordinance 2021. So this is the first thing, by this amendment only, that PPIRP came into place. The insolvency and bankruptcy pre-packaged insolvency resolution process rules you have to study, like in CIRP. You have to study the sections which are there. Then again, rules you have to follow. Then again, regulations are also there which you have to follow. Similarly, in pre-packaged also, all the things, 3 things are there. You have to follow that. So if you can make out the difference, this is the sections part. Sections where it is specifically mentioned what are the provisions in the code that you have to study. Then rules which are framed by the government, central government, that you have to study. And IBBI also frames some regulations, and that also you have to study, which is specifically for the PPIRP. And all this was notified in 2021 itself. What is PPIRP? In simple words, manner of resolution of a corporate person. Just mark these words. It is for corporate person only, because again and again we are saying that it is not for individuals. It is not for partnership firms. If an entity is registered as a corporate person, then only this will apply. So for companies, for LLPs, if they are considered as MSME, they can very well go into this process. So it is a manner of resolution of a corporate person wherein a resolution plan is formulated by the management of the corporate debtor. Now, see the difference. Here, a resolution plan is prepared by whom? Resolution plan is prepared by the management of the corporate debtor. That means the board of directors or the management team that will prepare the resolution plan. And this resolution plan is known as base resolution plan, in consonance with their creditors, while retaining control over the management and operations of the corporate debtor. So here itself you can make the difference between make out the differences between PPIRP and CIRP. Like here, the who prepares the resolution plan here, and in case of CIRP, who prepares the resolution plan. Here in this PPIRP case, the control is still retained by the management, while in case of CIRP, we all see that the management goes out of control. Now everything is being controlled by RP, and they have to take the directions from COC from time to time. But here, all the operations, management, etc., is being taken care or retained by the management of the corporate debtor itself. They are not out of their job. What is the background about PPIRP? We've already studied. what the amendment has taken place, a new chapter, chapter 3A, was introduced altogether to frame out the legal structure of PPIRP. So when you will read the code, you will have a separate chapter, chapter 3A, for this PPIRP. It is specifically designed for corporate debtors qualifying as MSME. Again and again, why we are discussing this is because whosoever qualifies as MSME only can apply for this. What are the key features? PPIRP is a quicker, cost-effective process than CIRP. How it is quick, how it is cost-effective, because many third party or the when you will study the rules and regulations, it is a very it is not very detailed thing, just like CIRP. They have cut short many things. So to make the process faster, to make it quicker, even the timelines you will see here, the timelines is lesser than CIRP. In CIRP, the timeline is, anyone can tell me what is the timeline to complete the CIRP process? How much is the timeline?
180 days plus extensions.
Okay. So what is here, we will see that it is 90 days, 90 plus 30 days it is mentioned here. Within that time frame you have to complete. So it is obviously quicker. It is specifically designed to serve the MSME sector. It also guarantees the continuity of the business by adopting debtor in possession model. So again and again, we are using this term debtor in possession. This is a new kind of model, new structure where the debtor does not lose his possession, his or her its possession basically. So the corporate debtor, the management team is still there. They still have the control. They still have the possession, as compared to CIRP, where board of director is suspended. PPIRP ensures that promoter continues to run the business. So this is the key point or the key takeaway, that in PPIRP, the whole and soul thing is promoter will carry on the business. He will continue the business. They will not move out of their job. It's not that the outsider will come and take control. It is just the promoter will continue to run the business. So let us first discuss the differences between the two, so that some things will be cleared in your mind, and then we will go into the details of PPIRP section by section. So what is the difference? The first difference is who is eligible. What is the eligibility criteria? In CIRP, as we know, any corporate debtor can opt for CIRP, while for PPIRP, only the MSME corporate debtor can opt for it. I think first point is very much clear. So again, one question which I asked in the beginning, if an entity is MSME, can they apply for PPIRP or CIRP or both? So specific provision is there in PPIRP, but if they want, they can still go for CIRP. But again, the threshold should be met. So the threshold limit for CIRP is 1 crore, while in PPIRP, the threshold limit of default is 10 lakh. So this is the major difference. Application by whom? Who can apply here? In CIRP, as we all know, operational creditor, financial creditor, or the corporate debtor, any one of them can apply. However, in PPIRP, it is only and only by the corporate debtor himself. It is not by operational creditor, not by financial creditor. Even we will see here that the terminologies here are used, only the creditor word is used here. It's not operational or this financial. They do not bifurcate in that category also. Next, who does the preliminary work before filing any application, or is there any work required before filing application? In CIRP, as we all know, until and unless the application is accepted by the adjudicating authority, there is no work to be done. However, in case of PPIRP, you have to work. And what is that preliminary work? You have to prepare that base resolution plan. So along with the application, you have to submit that resolution plan also. What is the time limit for completion? In CIRP, as we all know, it is 130 days and maximum it can go to 330 days. While in PPIRP, it is 90 plus 30 days. So 90 days for the completion of the process. You can just see that it is half of the time limit of CIRP. 30 days are given for the adjudicating authority to approve the resolution plan which is being given. So 30 days for them. So in total, it is making out to 120 days. So next point of difference is regarding the appointment of IRP. So in case of CIRP, yes, there is an appointment of IRP, which is later, whether he will continue or new resolution professional will come into place. That takes place in CIRP. So first appointment is of IRP, then we have resolution professional in case of CIRP. However, there is a direct appointment of resolution professional in case of PPIRP. There is no term like IRP in case of PPIRP. Next is concept of Swiss challenge, whether it is there or not. CIRP case, there is no Swiss challenge term is used here, while in case of PPIRP, we use this term Swiss challenge. Why this is used, we will discuss in later slides, because here the promoters are giving the resolution plan and it is being countered by the other outsiders. They can also submit their plans, and this continues till finally it comes to a satisfactory level. So that we will be discussing in later slides, but this is again a new term for you. In PPIRP, we use this term Swiss challenge. Next is base resolution plan.
Excuse me, madam. This concept of Swiss challenge is also prevalent during the CIRP.
No, sir, it is not. It is not there, sir. This is a new concept wholly and solely for PPIRP.
It is happening like, one has to go through, suppose somebody has come out with a resolution plan and somebody COC is of the opinion that there could this maximization could be improved, that then they might ask for this the resolution plan to undergo Swiss challenge.
That thing is happening. Revision of plan is there. Where we use the term revision, they can revise their plans. But this terminology of Swiss challenge is basically used in PPIRP. The process is similar as you are saying, but the concept is basically for this PPIRP. Next is base resolution plan. So this we have already understood that this base resolution plan is given by the promoters or the directors of the company at the time of submission of their application. So it is only in the case of PPIRP. Then vesting of management, who has the control of the management. In case of CIRP, it is with interim resolution professional or the resolution professional, while in case of PPIRP, it is still with the corporate debtor. These are the basic differences between CIRP and PPIRP. Can I move further or any questions till this point? Because we will be now dealing with the details of this PPIRP. Till now, we have just talked about the background of PPIRP, why it has been introduced, and what is the scenario in other countries, and we have just discussed that part. How this actually takes place, how you have to file your application, all that we will be discussing now onwards. So next topic is PPIRP. It is available to whom? Let us quickly revise. In respect of defaults, where default is at least, it is clearly mentioned the default is at least 10 lakh. Next, default that arose between 25th March 2020 to 24th March 2021. They can also avail the benefit of PPIRP. As you already, you might be knowing that during this period, during this COVID scenario, CIRP was not available. However, you can still apply for PPIRP. What is the meaning of default? Default, as we already know, it is defined in section 312 of the code, which means non-payment of debt when whole or any part of installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be. So even if you have partially paid, you are still considered to be on default because the whole amount has not been paid until unless you have discounted that or you have written it off. So if it is there in your balance sheet, you have to pay it. Otherwise, it is considered as a default.
Madam, the account need not to be NPA, declared as NPA for this default under PPIRP?
So normally, It is not that, because no, NPA term is basically for the banks. They declare it non-performing. So normally bank takes an action when an account becomes NPA. However, in case of operational creditor, if your payment is not being made, suppose within 40 days or 45 days, if you want to take an action, this act allows you to take an action. If your
Okay.
amount
This is with respect to section 9, I mean, operational creditor. In case like, if it is, if the default is against some bank facility, that means like an account need to be NPA.
So normally it happens that banks do not take an action until unless the account becomes NPA.
Okay.
So that is why it is a general scenario that when they consider that the account has become NPA, then only they file an action against the corporate debtor. But the act says as soon as the default is done, as soon as the default
Okay.
is there, you can come into this.
Okay. Got it.
It is nowhere written that it has to be an NPA only, then you have to come here. It is simply saying whenever it was due and payable. These are the terms. Whenever the amount was due and payable and it is not paid by the debtor, then you can file an application under this. Next point is defaults can be from multiple accounts aggregating to a minimum threshold of 10 lakh. I think this is very much clear that it need not be that only a single creditor should have total of 10 lakh. I mean, okay, let us take a scenario that XYZ company is the corporate debtor. XYZ, the private limited, is the corporate debtor, and it has defaulted in paying 2 lakh rupees to Mr. A. So now Mr. A, can he file an application for PPIRP because the amount of default is just 2 lakhs. So individually he cannot, but if he can have similar people where who have also not been paid by the same entity, and if the total amount of those persons is making this threshold of 10 lakh, then they can jointly file an application. This simply means this. So you can aggregate it also. It is not that a single creditor should be having this 10 lakh amount payable towards him. It can be a group of people. So aggregate amount will also come into the category of this threshold. And it is a well settled principle now. Any corporate person, that is a company or a limited liability partnership, which is classified as MSME under section 7(1) of MSME Act. We are just discussing the eligibility criteria, who can apply for this PPIRP. So till now, we have discussed who all are eligible. Now the question arises whether registration is compulsory. This registration means Udyam registration under MSME Act. So your turnover is lesser than suppose you are falling within the limits. You are micro entity or you are small entity, but you have not taken any registration under the MSME Act. Can you still apply for PPIRP? This you have to answer, and only then I can. Someone has asked a question. It will be better that you can speak that up. Debt is something and paid this much amount, default is this much. So let us come back to this question and we will take the questions in chat later maybe. Whether registration is compulsory. We are talking about Udyam registration. You can do your guesswork.
Yes, it is. Because see, because
let me
in
have your views also, yeah. Yes, please carry on, please.
yeah, because see, you have been categorized as a MSME. At the same time, like you are taking the advantage of this PPIRP, and in that scenario, I think you already fall in that, and registration, I doubt, like without registration you can initiate.
rephrase the question. Suppose I fall into the category of small enterprise. However, I have not taken this Udyam registration. Why I have not taken? Because I didn't know that I have to take that Udyam registration also. So I have not taken that registration. But still, as per the section 7 category, section 7 criteria, I fall into the category of small enterprise. Where is it written that I have to be registered also to apply for PPIRP?
Maybe not in PPIRP, but in various judgment. See, this benefit under CIRP is not you cannot take the benefit and initiate action in CIRP.
I'm getting my point. This might happen because you might be facing some clients, you might be handling some clients who fall into the category, but they don't have the MSME registration. What now? Can you apply for PPIRP? What is the option available to them?
First of all, I'll ask them to get it registered just to clear the doubt. Then I'll advise the client to go for any benefit which is applicable and which is available to them at that point in time.
Perfect, sir. It just takes 15 minutes to get this MSME registration. Gem registration is such a simple thing. You can instantly get the certificate within 15 minutes. And there is no hassle in that. So even if anyone is not having, see, registration is not compulsory. It is not directly written anywhere that you have to have registration. Even in MSME Act also does not talk about registration. That registration, you have to take registration. It is not mentioned anywhere. However, while applying for the benefits under MSME schemes or any portal like Samadhan portal I have talked about earlier, that you have to, if you want to take any benefit under that act, then you have to take the registration and then only you can apply for it. Otherwise, the benefit will not be given to you. But for the classification purpose, yes, you are classified as micro, small, or medium, even if you are not registered. Just to take the benefit of MSME schemes or anything like that, you have to have MSME registration. However, nowadays, in all kinds of bank loan, they are asking or they are mandatorily asking people to take this Udyam registration. They are not, banks are not providing any kind of loan facilities if a person is not having Udyam registration. So indirectly, anyone who is having loans, it has been made compulsory for them that they now have this registration, Udyam registration with them. However, there are some more cases, like I just said that it is nowhere written that registration is compulsory to apply for PPIRP. Just the conditions which we have read earlier, that it should be classified as 7-1, or they should be they might have made default of 10 lakh. The things like that only matter in case of PPIRP. However, when we go through the court orders, wherein this PPIRP application is accepted and rejected, so adjudicating authority, while drafting their orders, they specifically mention that this particular entity has submitted their Udyam registration as an evidence saying that they falls under, suppose, the small entity or this medium category. So in order itself, they are mentioning that this person has submitted this as a proof, because you have, along with your application, you have to submit some kind of proof that you fall into some category. However, that proof need not be this Udyam registration. You can share your financials also, saying that this is the investment, this is the turnover. But on a safer side, if you want to be, if you want your application to be accepted smoothly, you can apply with the Udyam registration. That is a better option. I think I've made myself clear. Any doubts still here? So even if
yes, what if I have applied for Udyam registration and due to some reason or what it has not come through and it is pending. So my registration sorry, my application still remain valid.
pending hota hi nahi hai. It is never pending. Within 15 minutes, you will get the registration. The site will, it will tell you what is the fault. It does not ask you to submit any documents. It is very smooth process. You just have to fill the form. You just have to
In
mention
case
the
it
details.
happens, I'm talking about in case it happens due to some technical glitch or something, like, the process could not, like, the process, I mean, takes more than 10 days, say, for an example. So how to, like, this my 10 days intervening period should be considered as?
So you have to actually, at the time of filing application, you might have given some other documents, right? To justify that you fall into this category. You might
So
be.
can I submit along with my application that my this registration is pending, though I have applied for it? Will that hold good till my final approval comes through?
Yes, sir. Anyhow, you have to justify that you fall into that category. You are fulfilling this criteria. That is what on your part is required. Udyam registration is a clear evidence, but there are other evidences also which proves that a person is small, medium, or micro. So there are different evidences you can give that also, and maybe meanwhile, because at the time of rejection of any application, sometimes maybe tribunal may ask for some additional information. Sometimes they keep on, before deciding, finally accepting or rejecting, they keep on asking for some more documents. So at that time, maybe if you have the this Udyam registration available, you can submit that later also.
Yes,
But
this.
it does not take very much time, sir. I have never seen that it, due to any glitch or something, it is pending. It has never happened.
It was just to have a safer side to, I mean, prolong my application till I have that registration in my hand.
So you can do that way also, sir. Otherwise, you can later on also submit as an addendum. Okay, can I move further? So this we have already covered. This thing is not to be discussed much. These are the relevant sections. So if you all are awake, just let me know, because these are the sections which we will be discussing now. Are you all awake? Can I hear from you? Because this will be somewhat in study mode, which we will be doing. You want a break, or we can continue, as you say?
You can have 10 minutes break.
What about others? Please say something. Please use the chat box. It is for you only. Okay, some people are saying continue. Okay, then let us continue for some time, and maybe later we can take a break. Okay. So as you can see, okay, if you remember, I told you earlier that there's a new chapter, chapter 3A, which was introduced. And in that chapter 3A, these are the sections which are incorporated or which are introduced or inserted specifically for the PPIRP. So section 54 onwards, 54A, 54B, C, D, E, all these are for PPIRP. If you can just read the name of the section also, you will come to know what it is all about. And later on, we have just the details. So let us understand how this whole PPIRP is structured. So 54A section tells about the corporators who are eligible for PPIRP. This, I think, now everyone knows who all are eligible. So what is the criteria that is mentioned in 54A? Next, 54B talks about the duties of insolvency professional before initiation of PPIRP. Normally, your duties starts after application is admitted in normal CIRP cases. But here, your duty will start even before initiation of PPIRP, and that is, assisting the management in preparing that base resolution plan. So that is the duty which is mentioned in 54B. Next is 54C, application to initiate PPIRP, like in which form you have to apply, what are the things you have to, who can apply and how it will be done. So that is what it is mentioned in 54C. Then 54D, time limit for completion of PPIRP. Within what time it should be completed? We have already discussed it. Can anyone tell me, if you remember, what is the time limit for completion?
Completion is 90 days plus 30 days extension
Right.
for passing of a resolution. And more thing, my question would be like, so that who appoints the IP in this PPIRP?
We are just
And how does management, how the management and bank?
checking all. I'm just reading out the section name.
Ma'am, your voice is not audible.
Sir, we will be discussing each and every detail in next slides. I'm just reading out the names of the section right.
Okay.
Good that you have question in your mind, and that is why these slides are there. You just keep adding questions to your mind, and we will get the answers for all of that in the next slides.
It is difficult to, I mean, keep all these questions like in any, like in, it is always better to like, get it clarified when it that like in any topics comes which is more relevant.
Because it is
This
discussed.
is my request. This is my request.
So how they are appointed and all, that is management nominates basically any insolvency professional in their application itself, that we want this person to become our insolvency professional, and thereby they get appointed.
The bankers have got to do anything with this at this stage? No. Financial creditor?
No, sir, they don't have to.
Okay.
Okay, so next is 54C, we have dealt with 54D, we are done with this. 54E, declaration of moratorium and public announcement during PPIRP. It is similar to CIRP, like as soon as the application is accepted, this moratorium and public announcement is there. Then 54F, duties and powers of resolution professional during PIRP. Can you make out a difference in 54B and 54F? Both are related to duties of insolvency professional. 54B talks about before initiation of PPIRP, and 54F is talking about during PPIRP, what are the duties and powers. Next is 54G, what are the list of claims and preliminary information memorandum. So as you all know, in CIRP also there is this information memorandum. So here we are using the term preliminary information memorandum, and again list of claims will be prepared, whose amounts are due, whose payments are not done so far. So all that list of claim will be prepared. Then 54H, management of affairs of corporate debtor. Who will take care of the management of affair? In simple terms, if I answer this, it is the promoters themselves. They will be managing. There will be no change in the management of affairs. It will still continue to be in the hands of the promoters, directors. Then 54I, it is the committee of creditors. How this committee of creditors is formed and how is it different in this case from CIRP? That we will be discussing here. Committee of creditors. Then 54J, vesting management of CD with resolution professional. How much power does resolution professional has? We will talk about this. 54K, consideration and approval of resolution plan. Finally, if you have all the resolution plans, that will be discussed among the team, and then finally it will be approved in the meeting. Then it will be given for further approval to adjudicating authority in section 54L, which is simply the approval of resolution plan by adjudicating authority. Then in 54M, we can appeal against the order under section 54L. So if you are not satisfied with the order of NCLT, you can further go for appeal, which is mentioned in 54M. Then 54N talks about the termination of PPIRP. When will this PPIRP come to an end? So there are various scenarios when this PPIRP come to an end. One is simply that when the resolution plan is accepted by all, it will come to an end. And there are other more also. So we will discuss it there when we will take the detail. 54O, initiation of CIRP. So in PPIRP itself, it is saying that now CIRP can be initiated. Can you see this? 54O, it is talking about initiation of CIRP. So it is coming after 54N, if you can see that. Then PPIRP has terminated and there is no alternate in PPIRP. Suppose there is no resolution in PPIRP. Now you can go for CIRP. This option is also there. So this is mentioned in 54O. Next is 54P, application of provisions of chapters, all these to this particular PPIRP chapter 3A. Normally, what all sections are applicable to CIRP? Procedural sections, I would say. The same procedural part is applicable on this PPIRP as well. This is mentioned in section 54P. So this is the complete checklist of PPIRP sections checklist, I would say. So starting from 54A till 54P, we have this. So now let us go into details. We are discussing 54A. You can see here section 54A, subsection 2, A to D, subclauses A to D. So here, what is the basic thing mentioned in 54A? As you know, the heading of the section was eligibility. Who are eligible to file application in PPIRP? So eligibility criteria is specifically discussed here. First thing is that entity, that corporate debtor should not have undergone PPIRP or CIRP during the preceding 3 years. So this is simply known as cooling off period. If an entity has undergone CIRP, suppose this year this has undergone CIRP, then for next 3 years it cannot opt for this PPIRP. So cooling off period has to be there. So whenever a PPIRP application is filed, previous 3 years are checked by the adjudicating authority whether any application from this particular corporate debtor was filed earlier also for CIRP or PPIRP, whatever the case may be. So it should not have it should not have undergone PPIRP or CIRP. This is what is mentioned here. Next is it should not have it is not undergoing CIRP. So the first point was the process is already over. CIRP or PPIRP process is already over. They are again applying for PPIRP after 3 years, maybe. But here it is saying that application is already filed in CIRP, maybe in section 7, 9 or 10. And similarly, again, you are applying in PPIRP. So this should not be a case. If a person is already undergoing CIRP, the application cannot be filed in PPIRP. But if the application in CIRP is not accepted, till that time you can apply for PPIRP. But if the process has started, then you should not apply for PPIRP until unless this process gets over and 3 years are elapsed from that. Is there any doubt in these 2 points? Okay. I believe it's clear then. No liquidation order has been passed against the corporate debtor under section 33 of IBC. So why it is saying no, because these persons are not eligible. If liquidation order has been passed already under section 33, then that entity cannot apply for PPIRP. This is basically meant here. And since you can see, and so all these conditions are cumulatively to be seen. So this is the last condition. Eligible to submit a resolution plan under section 29A of the code. So 29A, as we all know, is the disqualification criteria. So if a person is willful defaulter or does not fall under the qualification category of 29A, then they cannot file PPIRP application. Otherwise, they can file. So this is what is meant here. A person has to be eligible as per 29A. So again, the checking of 29A section will be there. Whosoever has applied, we will check all the condition, whether the person is insolvent or not, whether he's of sound mind or not, all those categories which are mentioned there. So we will check that criteria. If a person is eligible under 29A of the code, then only they can apply here as well. I hope these points are clear. So for filing PPIRP application, these are the 4 basic things which must be taken care, and then only the application can be filed. Otherwise, it is bound to be rejected. Can I move further? Okay, thank you. Filing PPIRP application. So how to file this PPIRP application? Like now you have got somewhat idea. Now you might be, willing to know how to apply this application. Suppose I have a client and I want to file an application. So how to do it? What is the procedure? So these are the steps which you need to follow before going for the application. Firstly, you have to pass a special resolution, or more than 3/4 of the partners must pass a resolution approving the filing of the application for initiating PPIRP. Like in case of companies, normally the decisions are taken by the shareholders. So a special resolution is required for that, because you all know in company law there are two kinds of resolution, ordinary or special resolution. So if you want to go for PPIRP application, you have to get a special resolution. You have to call a meeting, take a special resolution, and get an approval from the shareholders, and then only you can apply for PPIRP. It is not just the management decision. Only the board of directors cannot decide and apply for PPIRP. It has to be a special resolution. In case of LLP, it is said that 3/4 of the partners must pass a resolution. So similar to special resolution, 75% majority has to be there for filing this PPIRP application.
Madam, that means like the corporate data or the management, I mean, should have this resolution in hand before approaching the financial creditor?
Yes, sir, this should be on record. This has to be submitted along with the application.
No, I'm talking about like, when your application is like, it calls for at a later stage. Suppose like, I wish to take the benefit of this PPIRP and I want to approach I mean, my banker for resolution. That point in time, like, I should have at this resolution ready with me.
So this is the starting point. You cannot apply for PPIRP if you don't have this special resolution. Like what happens if, let us just take a scenario. You and I both are owning a company. So we are the directors of that particular company. And both of us are the shareholders also. Let us take 3 persons, that would be better. So 3 people are there in the board of directors. And we are the shareholders. There is no one else. So like suppose I come up with this idea that let's go for PPIRP because we are having so many outstanding creditors. We need to pay them off. We are unable to pay them off. So let us go for PPIRP. I have attended a session and this is very good option available. This is my idea. I shared with both the directors first. So in the board of directors meeting, firstly a board resolution will be passed that yes, we can go for this. And then we will have a special resolution also, because we are the shareholders. We will pass a special resolution also. So suppose if 75% majority kind of, so if two people are agreeing, then we can go for this PPIRP. So what is the basic step? We should have the resolution. Then we will prepare the base resolution plan. This is step 2. And then moving on. So this is how it is going, sir. We are not filing any, like we file section 7 application, we file section 9 application. We have not reached to that point, sir. We are much before that. We are just discussing it within the team, whether we should go for PPIRP or not. So if board of directors are agreeing, shareholders are agreeing, then only we have made up our mind that yes, we can go for this PPIRP. Then what is the second step? Second step is to prepare this base resolution plan. And then we will
This is
see.
just like a voluntary liquidation
Yes, sir. Yes,
procedures.
sir. Yes, sir. Similar. Yes, exactly. So we need to understand the steps. So if any client comes to you, or in fact, how will client know that this kind of scheme is also existing? You have to pursue your clients that this scheme is also available. So you will ask your clients to take a special resolution, call a meeting, take special resolution, and then proceed with this. So at least you should have a basic idea how this goes. So first step is to take the special resolution. Second is to prepare a base resolution plan. Third step, director's declaration. So directors have to give a declaration. What kind of declaration does a director has to give? Each and every director has to give this declaration. Application would be filed within 90 days. Which application? This PPIRP application. Application to whom? To adjudicating authority. That means whatever form is required, after taking this special resolution, it will be filed within 90 days. So can you make out what is said here? It is basically telling you the life of this special resolution. It will be there only for 90 days. So whatever resolution you have taken, it will expire after 90 days. And if within those 90 days you could not file that application, you again have to do all the proceedings. You have to again take a special resolution, prepare a base resolution plan, and then you have to submit. So 90 days are given to you to work upon as soon as you have this special resolution. Are you getting this point? So the dates will
Yes.
be. So at the time of filing the
That-
application, the adjudicating authority will cross-check it with the special resolution date, on which date the special resolution was taken, whether application has been filed within 90 days. If yes, they will check the other points then.
That means the pre-initiation stage should be completed within this 90 days only.
Exactly, sir. So firstly, director is declaring whether he has done or not, that is different issue. Firstly, he is declaring that he will be doing it within 90 days. Second, PPIRP is not being initiated to defraud any entity. This is a declaration mandatorily to be given by the directors, that they have to confess that we are not doing it in any way to defraud any entity. It is a genuine case. We want to apply for this. It is not that we are, siphoning off funds like that. So they have to clearly say that we are genuinely applying for PPIRP. Our intention is not to defraud anyone. This is what declaration is to be given from their side. Third is particulars of the resolution professional. See, as you asked earlier, who will be appointing resolution professional and all? Nomination will be done by the directors. They are, in the declaration itself, they are mentioning the particulars of the resolution professional, like name, what is his registration number, etc. All the details are given by in the declaration of this director. All the details are there. So these three things are to be given as declaration. Next, approval by 66% of the unrelated financial creditors. Okay, let's just go back again and understand the whole scenario, what steps we have seen till now. Firstly, you have to take a special resolution. Then you have to prepare a base resolution plan. Then you have to obtain the director's declaration. Therein, 3 points are to be mentioned. First is that application will be filed within 90 days. PPIRP is not initiated to defraud anyone. Particulars of the resolution professional are also mentioned there. Then now you have to call a meeting of unrelated financial creditors, which is just like COC meeting you are having. So this thing, this PPIRP thing that you are applying for, that this has to be approved by the 66% of unrelated financial creditors. This has to be approved.
Madam,
Then
voting, how it is to be considered remaining present all through?
just like in earlier cases, because we have read one sentence, if you could make out, it is saying that similar provisions will be applicable on this chapter. Like in
Okay.
CIRP, voting process was done, similar rules and regulations will be there for voting here also.
Okay.
Nominate an insolvency resolution professional, and such nomination must be approved by 66% of the unrelated financial creditors. So whomsoever you have nominated, you have already given the particulars of that resolution professional. Now that resolution professional also has to be approved by 66% of the unrelated financial creditors. So
So
this is
that means the IP's work starts from here.
yes, sir. So that is why we were saying that preliminary work is to be done before even filing the application. His work starts. And here the role of insolvency professional is just simply known as resolution professional. He's not considered as IRP. He's directly considered as RP. Is there any question in chat? No. Okay. So let us go through the checklist again before filing. application for PPIRP. So even before filing the application, these are the steps which you need to take care. First and foremost thing is the minimum default criteria. Whether the entity is meeting the minimum default criteria, what is it? 10 lakhs. So if default criteria, threshold criteria is there, then step 2, approval of the members, that is special resolution in the general meeting. Then formulation of the base resolution plan. Then approval by unrelated financial creditors. It should be more than or equal to 66%. You can here it is just mentioned that the quorum is to be present and all that. Then application for initiation of PPIRP subject to certain conditions filed by the corporate debtor. Then if you have the majority, then finally it is said that you can file an application for initiation of PPIRP. And then it is admitted or rejected, as the case may be, by the adjudicating authority. And suppose admission is made, then commencement of the PPIRP will happen. And if admission is not there, so in simple terms, if this application is rejected, then it is simply known as termination of PPIRP. Is this flowchart clear to all? And here it is said that from this third point, this approval of unrelated financial creditors, from here till admission, duties of RP starts. And here he has to file a report under in the format P8. We will study the formats also. Are you all with me till here? I should also receive 66% votes.
Please go ahead.
Okay. Let us now understand what is base resolution plan, because again and again we are talking about this base resolution plan. Let us know the preliminary things about it, that it is prepared by the management in consultation with the insolvency professional. It is to be submitted along with the application of PPIRP to the adjudicating authority in the first stage itself. Normally in CIRP, when the application is accepted, then we call for the resolution plans. But here, base resolution plan will be submitted by the management itself, along with the application. So what is the definition? According to section 5(2)(a), base resolution plan means a resolution plan provided by the corporate debtor under clause C of subsection 4 of section 54A. It should be in conformity with section 30, as we all know of the code, and presented in the first instance to its committee of creditors, that is COC, for consideration after the PPIRP application is admitted.
And madam, if I am not wrong, who bears the cost? It is the management?
Yes, sir.
Of the CRP cost?
Yes, sir. Yes, sir.
Okay.
Until unless it is admitted, everything is borne by them. Time limit. According to section 54K, corporate debtor shall submit this base resolution plan to the resolution professional within 2 days of the pre-packaged insolvency commencement date, and the resolution professional shall present it to the COC. So this is simply written here that to COC, when is the time to present it to COC? Within the corporate debtor will firstly give it to resolution professional within 2 days of the commencement, and then they have to present it to the COC in the meeting. Then approval. It must be approved by 66% of the COC. So if this base resolution plan is approved by 66% of the corporate committee of creditors, then finally it is approved within the committee, and then it will be given for further approval to the adjudicating authority. But what if it is not being approved, and what are the reasons for rejection? If the base resolution plan impairs any claim owned by the corporate debtor to the operational creditor. So what could be the reasons? We are just analyzing what are the reasons of rejection, why the committee of creditors is not accepting this resolution plan given by the management. So one reason could be the haircut is too much, or they have simply kicked off any of the operational creditor. They are not intending to pay to any operational creditors, or they are paying them very low, then in that category, they may reject. The COC may reject her. Next is commercial feasibility and viability criteria is not good. So if this is the, as we all know, the COC has the commercial wisdom with them, they can commercially or feasibly check the viability criteria, and if it does not suit them, then they can straight away say, or they can say straight away reject this plan. What if BRP is rejected? So what happens if this base resolution plan is rejected? So till now, what we have understood is management submits its base resolution plan. They provide the whole scenario that suppose there is an operational creditor who, though we owe him suppose 1 lakh rupee or something, we are just paying him 25,000. This is there in their resolution plan for each and every financial creditor, operational creditor. They have mentioned to whom they will be paying how much. But if by chance that resolution plan is not accepted, we will call it base resolution plan because this is the initial resolution plan which the company has given. So if this resolution plan is accepted then and there, then the PPIRP thing is done. We are good to go with the process. The process is already completed, I would say that. But if this base resolution plan is somehow rejected, the committee of creditor feels that the management has done a lot of haircut and we are not satisfied with this plan. We want to have some more plans. So in that case, we are studying this particular slide. What if the base resolution plan is rejected? How the process flows in that case? Resolution professionals shall invite prospective resolution applicants, that is PRA, to submit resolution plans. So just understand the difference. In CIRP, from the very beginning, you invite prospective resolution applicants. But here, the role of prospective resolution applicant arises only when this BRP is rejected. Is that clear? If the base resolution plan is rejected, then only the others or the outsiders will be asked to submit their resolution plans. Is it okay? Can I go ahead?
Once that PR is invited,
Yes,
can
sir.
corporate debtor, I mean, go for taking over the company as in the CIRP, being in the capacity of
We have just
MSME?
invited them. Wait, what happens? We have just invited them. Whether their plan will be taken or there is some other story also, we should first understand.
I think Swiss challenge should come into picture.
Yes, sir. Now, COC shall lay down the eligibility criteria for the PRA and basis for evaluation. So this is just the evaluation metrics, as we all know, to evaluate the resolution plan received from PRA. So they will decide a metrics or they will have some evaluation criteria on the basis of which marking will be given to them. Based on the criteria mentioned above, highest scoring plan is considered for competition with BRP. Now, whosoever has scored highest, the COC will take that plan and it will be compared with the base resolution plan. So we have two plans in hand, the highest scoring plan and the base resolution plan. If such plan, that is the plan with highest eligibility score, is significantly better, this term is very, very important. If it is significantly better than the base resolution plan, then such plan may be approved by 66% of votes of the COC. So if it is outstanding, I mean, if there is no better alternate than this particular highest scoring plan, then they can straight away approve this plan with the requisite majority of votes. But if this significantly better term is not there, they still want the promoters to compete with this plan. They may use the other option that we will be studying now. What if no plan is significantly better, or you do not have any plans at all? What will happen in that scenario? RP shall disclose the score of PRA's plan selected and the BRP. RP shall provide an opportunity to such PRA and the corporate debtor to improve their respective plans. So you see here, both the parties, that is the corporate debtor as well as the prospective resolution applicant, both are allowed chances to keep improving their respective plans. And it is just kind of a bidding process, that I'm giving this much bid and the other person is giving this much. So they are keep on. It is an ongoing process by making alternative improved submissions, starting with the plan with the lower score. Just whosoever has a lower score will say it first. Improved submissions process shall continue till one of the submitters, that is either the corporate debtor or the prospective resolution applicant, fails to utilize the opportunity to improve the plan. So whosoever raises his hand that, yes, boss, I'm done, there are no further corrections, this is it, this is what I could submit at my best, then the process will come to an end, and then final analysis will be done by the COC. The disclosure of the scores by the RP and the submissions of prospective improved plans takes place in a 48-hour window, upon the expiry of which the resolution plan with the higher score shall be considered for approval. Since this kind of thing is happening here, revision of plan again they are submitting, that is why it is known as a Swiss challenge. This is happening here. And here the time limit is also mentioned. Within 48 hours, if you do not get another plan, then final judgment will be done by the COC, whomsoever they want to accept, higher score person. Next topic is handing over the management to the resolution professional. So as we know, this is a category wherein debtor is having the possession. Debtor means the corporate debtor is having the possession. Now there are some part of their job, they are handing it over to resolution professional, like day-to-day activities or maybe the compliance part or something like that. So how this is taken care, how the handing over of the management is done to the resolution professional. At any time prior to the completion of the termination of PPIRP, 66% of the COC can cast vote to divest the management of the corporate debtor and hand over the management to the RP. Normally, RP does not get the complete management in his hands, but it is mentioned in the code itself that at any time it is an option given to COC if they can vote it with 66% to divest the management from CD and hand it over to RP. This is possible. So if any time COC is of the feeling that corporate debtor is not able to handle the management in a better way, then they can ask a resolution professional to come into picture, and he may be asked to take over the possession or control. But again, it is said that 66% voting is to be done by COC. Adjudicating authority may pass an order on the application made by the RP in this regard if adjudicating authority is satisfied. So firstly, we have seen that COC themselves have a power to hand over the management to RP. There is another case here. Adjudicating authority may pass an order on application made by RP in this regard. So resolution professional can on his own also ask the adjudicating authority to pass an order that the affairs of the corporate debtor have been conducted in a fraudulent manner. Wherever he finds that some fraud is going on, RP may directly on his own file an application to adjudicating authority and may ask the adjudicating authority to hand over the management to him. So there are two scenarios when RP will gain the control of the management. First is when COC wants them to take control. Second is when anything fraudulent is going on and RP has applied to adjudicating authority and they are passing the order likewise. And second is there is gross mismanagement of the affairs of the corporate debtor. Then also this RP can apply to adjudicating authority for this particular thing. Let us quickly understand the role of insolvency professional, and then perhaps maybe we can take a small break. What is the role of insolvency professional? They have a dual responsibility as an advisor to the corporate debtor till the filing of the application. As we know, this is known as preliminary work. and thereafter as a resolution professional as appointed by the financial creditors under PPIRP for emissions. So earlier this question was asked how this IP or the insolvency professional is appointed here. So nomination is done by management, then it is approved by the financial creditors and appointed finally. So this is how the appointment procedure goes. IP may be same or different during the above phases. You may, just like in CARP, we can replace the resolution professional. Similar things may happen here also. And again, he has to give a consent. Uh, he has to make public announcement. He has to appoint registered valuers. Whatever responsibilities you can make up for the resolution professional, all that he has to abide with. And these are a few responsibilities which are mentioned. This is the application format. I'll just take this slide. Maybe we can take a break. So how to initiate PPIRP? Form 1 is there, and Form 1 is to be accompanied with all these things. First is record of default. You have to provide a record of default that this much amount is pending, this is outstanding, we have to pay. Consent of IP proposed to be appointed as RP in Form P1 itself. Approval of unrelated financial creditors for initiation in Form P4. Consent of the IP proposed to act as AR, if any, in Form P5. Declaration by the directors, as we studied earlier, some declarations are to be given by directors or partners, which is to be given in P6. Members' resolution or partners' resolution. This resolution is that special resolution which we talked about. Declaration by the corporate debtor regarding avoidance transaction. That means there is no fraudulent transaction. This also declaration has to be given. Then report of the RP in Form P8. So here RP will say that all the compliance part is done and this entity is good to go with this PPIRP. What all he has checked, that format is given. P8, you have to completely file that. Then audited financial statements also you have to submit in the first application itself. See, at the time of filing the PPIRP application, on that time itself, you have to file these audited financial statements of last 2 financial years. Then a fees of 15,000. This is what you have to file. The date on which adjudicating authority admits the application will be the date of commencement of PPIRP, and from the date of commencement, the time limit will start, 90 days. Can we take a break? How much is your stamina? How's the Josh?
Okay. One question here, small question.
Yes.
The CD, the corporate debtor can withdraw this initiation of CRP at what stage, if so? Is there any? I said the CD, can CD withdraw the application and withdraw this PPIRP once the resolution is passed?
Yes, sir. Withdrawal procedure is available. And in reality also, people have withdrawn.
Because see that
before admission, you can always withdraw.
yeah, the
Yes.
whole that what it transpires from the procedure, like when I see that okay, that I cannot win the Swiss challenge, that it is better to withdraw. Why should I put my company into this kind of situation where somebody else will to come and take over the company?
100%, withdrawal is allowed. Before admission, you can.
Okay, at what stage, madam?
So before admission, I'm saying you have to file an application.
Before admission.
Withdraw. Of course, you have to file an application, only then you can withdraw.
Okay.
So after filing an application, before acceptance of that application, before admission of that application. Okay, so we are taking a break now, and we will assemble at 5:10. Is it okay? 10 minutes break. अभी तो yes बोल दीजिए.
Yes, बोल रहा हूँ मैडम.
Thank you so much. Thank you. Okay. Hello, so everyone is there? Can we start?
Yes, we can start.
Okay, so I'll share my screen again. Okay, so just let me know if you can see the screen.
Yes, visible.
Okay, thank you. So we have discussed which form shall be filed for the initiation of PPIRP. It is Form 1, and along with this Form 1, all these things have to be submitted.
So it is to be filed under section 10 or
No, sir, 54A वाले सेक्शन चल रहे हैं ना सर अभी तो?
नहीं, ये तो चल रहे हैं सब। फॉर्म 1 आपने बोला है, तो ये फॉर्म 1 वही फॉर्म 1 सेम फॉर्म 1 है जो।
नहीं सर, अलग है, PPIRP का फॉर्म अलग है सर।
अच्छा।
हाँ जी। So to whom this application shall be filed? The corporate applicant shall file the application in Form 1 with the adjudicating authority, जो भी NCLT bench होगी वहाँ पे ये जाना है. The corporate applicant serves a copy of the application to the IBBI also before filing the same with the adjudicating authority. So it is clearly mentioned there, before filing this application to NCLT, one copy is to be served to IBBI. The acknowledgement of serving a copy to the board shall be attached with the application form filed with the adjudicating authority. So this is also a kind of attachment which you have to do along with the application form.
Madam, whose duty is to file this form with IBBI? Is it management or incoming IP?
So normally the things are, this thing should be done by the management, but normally they hire a professional to do all this, no? So normally RP does that.
So it is the duty of RP. Unlike in other.
Because if he is filing, he will be charging fees for that also, no? Prior work, whatever he has done, he will be filing fee, he will be charging fees for that. If the management can work on their own, they can do it on their own. There is no requirement of RP. But normally it does not happen that way. They always hire a professional service, this thing. So though it is not mentioned anywhere that whose duty it is, normally it is because application is filed by the management. That is what is written. And normally management does not do anything on its own. They normally charge some professional person to do all these activities.
So that means some other professionals can file on behalf of management. There is no foundation on that, and it will not be, I mean, violation of any.
But why
If it is filed by
other person will file? Because as we have seen that the insolvency professional is asked to prepare the base resolution plan also, because he has been involved from the very inception. So he will be filing the this application. Why would any other? Why do you want other professionals to come into and take our job?
No. Just like, just see, IPs are running at the edge. Like, you never know when you are like, tumble, and you've been penalized for that.
See, we are filing the application, but it is not our duty. Am I clear then that way?
Yes.
Yeah, because still for filing application, you cannot be penalized for anything.
Yeah. So the whole idea is not to fall in that, I mean, that you have
No, sir.
crossed the boundaries somewhere.
Nothing will happen, sir. Till the time you are filing the application, nothing will happen. It's only after filing the application, some of the other people will get hurt or some objections will be there, and then maybe resolution professional, normally he gets some or the other kind of cases or show cause notices from the other parties, or the cases are filed from the other parties after the admission.
otherwise
Normally,
तुरंत DCN issue हो जाएगा.
बिल्कुल sir. Consequences of filing application. So now when you have filed the application, who will be or what will be the consequence? So normally, what do you think? What will be the consequences? Either the application would be accepted or rejected. Normally, this is what we can make out. Let us see what does this slide hold for you. Admission or rejection by the jurisdictional NCLT, and the time limit is also mentioned there. Within 14 days of filing, NCLT should accept or reject. See, these timelines are given theoretical, as we all know. Practically, this thing does not happen within 14 days. So, though they have mentioned it, it should be done in 14 days. But see, it's mentioned for both. If you have to accept or you have to reject, both have to be done within 15 days. The date of admission is the insolvency commencement date. This we studied earlier also. Moratorium is declared effective from the insolvency commencement date. As soon as the application is admitted, from that date, moratorium takes place. Confirmation of the appointment of RP. From here onwards, we can say that RP is appointed. And from now onwards, your duties start. All that
And
was
madam,
previous.
and madam, the look back period will start from this date of commencement
Yes,
here in
sir,
this
yes,
case.
sir. Yes, sir.
Okay.
Yes. All the provisions are same, sir. As
Okay.
we have studied in CIRP, they are same. Just a few things are different. Public announcement of the initiation of PPIRP is to be made by RP. So public announcement is also to be made. Then these are the various forms. I will not be reading out it fully, but these are the various forms. Form 1, which is given in rules, and rest all other forms from P1 to P3. See, this P indicates PPIRP. So these are given in regulations. A separate regulation is there for PPIRP, as I've already told you earlier. Similarly, separate rules are there for PPIRP. And so this form 1 was the application by corporate applicant to initiate this PPIRP process. So this was the form. Only one form is there in rules. Rest all other forms are there in the regulations. It contains like written consent, list of creditors, etc., etc. Everything. Then to file which form, all those are details. I don't want to bore you with all these minute details. So just I'm walking you through what are the various forms. This is again a summarized form of the sections as well as the kind of activities which you have to do and the timelines for that. So as we know that timeline is given in the regulation starting from which date, and it should end till 120 days, it is mentioned here. Like you can see, commencement date will start as soon as the PPIRP is started, and 54C is the section for the commencement and appointment of RP. And from that date, it is considered as T. And from that, time limit will start. So then various things will happen just in the same way as you know. Preliminary information memorandum shall be given. Base resolution plan will be discussed with COC. Constitution of COC, see here it is mentioned 54I. Constitution of COC, this is done within 7 days from the commencement of PPIR. Then first meeting of COC, this should be held within 7 days from the constitution of COC. Then submission of IM, etc., etc., everything is there. And then 90 days it is mentioned. Till 90 days, submission of COC. I'm reading the second last row. Submission of COC approved, resolution plan, application for termination of PPIRP. In both the scenarios, within 90 days it should happen. Normally, these timelines are just theoretical. As we all know, these things do not take place as they are given in the law. But however, they say that this is a easier process. And finally,
And the fees of IRP is same as of
that is again mentioned
newly
in the rules and regulations. In regulations, you have the separate fees. Fee structure.
No, it has been recently amended, so the same rule is applicable here also, so far as fees is concerned.
Fees only at one place they keep the things. There is no separate amendment in these regulations. This is what I know. So for the fees part, whatever you are, maybe if there is any amendment in the fees, that will continue to be here. Because for fees, sir, only one circular or notification is passed by the IBBI. And that takes care of every kind of activity done by the resolution or insolvency professional, rather, I should say. So in one notification or circular, whatever it is, they will have the complete detail. Finally, we are over with this, but let's see what does this slide tells us, that termination of PPIRP, how does it happen? So if the base resolution plan is accepted by 66% majority, then PPIRP is over. That is case one. Case number two, then you have invited other persons and you think the other plans are better or whatever the case may be. Finally, you have reached to a conclusion of and you are satisfied with that plan. Then again, it is over, PPIRP is over. What could be other scenarios that we are considering here? So the AA, the adjudicating authority, may pass an order of termination in the following cases. First is when COC passes the resolution seeking the termination. So again, they have to apply that we want to terminate. COC passes a resolution saying that this plan is approved, and when the plan is approved and it is taken further to adjudicating authority, in that they can seek termination also. Resolution plan is not submitted to adjudicating authority within 90 days. So as we know, the time limit is there. If within 90 days, this resolution plan is not submitted to adjudicating authority, this PPIRP process will be terminated. Resolution plan approved by the COC is rejected by the adjudicating authority, because this kind of situation can also be there, that COC is approving the plan, but the adjudicating authority is not satisfied and they have rejected it. In that scenario also, it is a termination. When conversion takes place, that is an important thing. COC can pass a resolution that is 66% to convert PPIRP into CIRP, and adjudicating authority would pass an order terminating the PPIRP. So it can happen anytime in between. So whenever PPIRP, during PPIRP, COC can pass a resolution with 66% majority to convert this PPIRP into a CIRP. And in that case, this PPIRP process will come to an end. So let us discuss now what is the current statistics. We have discussed the theoretical part, how the whole PPIRP functions. But what is the current position? In 2021, this PPIRP concept was introduced. And what is the scenario till 2024? This is the updated status I'll be discussing with you. So how many applications are admitted in 2021? Only 2 applications were admitted. One was rejected and nothing was approved. This others, I'll be discussing in a short while. What has happened with this others, I'll discuss it in a short while. So in 2000, let us discuss these year-wise data first. In 2022, again, 2 applications were admitted and 1 was rejected. In 2023, the score has increased. 3 admitted, 1 rejected, and 5 got approved. So whosoever has applied earlier, maybe in 21 or 22 or 23, their application have got approved. The resolution plans have got approved here in 2023, but till date only 5 resolution plans have been approved. 1 has been withdrawn. As you were asking, who can withdraw, when to withdraw? Yes, withdrawal is allowed, and so far 1 application has been withdrawn. In 2024, that is January, February, March till March, 5 applications have been admitted so far. So I was talking about this others. What has happened here is when the corporate debtor filed the application for PPIRP, the opposite party, that is the creditors, financial creditors or operational creditors, they filed an opposition. They challenged it that you cannot file a PPIRP. So since this was challenged, adjudicating authority asked them to give reasoning behind. They were asked to submit within 2 weeks the reasons for challenging this particular thing. And at the same time, the applicant was also asked to file a rejoinder if they want to express something new. So they were given that time. But during that, after passing that time, also the other party did not file the reasoning. So that is why it is mentioned here that twice it has been uh, 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 kept as in a different category, others. So once application was filed, but it was kept on hold because it was being opposed by the creditors. Then later on, creditors filed their reasoning, but the corporate debtor did not counter the reasoning. Adjudicating authority wanted the corporate debtor to also reply to the opposition parties' counters. So that is what was missing, and therefore this is on hold. So this is how the current status is. What are the practical challenges? As in the beginning also we talked about it, bankers are reluctant to take any MSME through the pre-packaged process, fearing a deal here. They rather prefer one-time settlement without involving any court. So only 4 MSMEs have been admitted. This is a previous image. So right now, as we know, in 2024, it is 5. Till date, it is 5. So they have been admitted through the process and none have been resolved. So it's okay. This is a previous kind of thing. Government is working on allowing the scheme for even larger companies. So a short test for all of you. If you are ready to take a quick test, say yes or no, please. I want to see your Josh. The theory part is done, and let's see how many of you have understood it. I don't think many people like to take tests, but the takeaway is in this slide only. So you have to be there. You have to take the test. So question number 1, whether willingly or unwillingly, please answer in the chat box. Can a corporate debtor who has been resolved under the PPIRP file an application for CIRP? I'm waiting for you all to answer. Yes, I've got one answer. Okay, Abhijit ji has also answered. Rajkumar sir has answered no. Jerome ji has answered. What about others? Pass. You have passed this question. Don't want to take this? Okay, the answer is corporate debtor in respect of whom a resolution plan under PPIRP has been approved in the 12 months preceding the CIRP application is barred from initiating CIRP. And in this case also, in PPIRP also, we saw the eligibility criteria of cooling period. If you remember, 3 years wala jo criteria tha. Cases of simultaneous application for CIRP and PPIRP. Whether simultaneous applications can be filed for CIRP and PPIRP. This also we discussed it. And a detailed circular was issued for this particular matter because in the year when this PPIRP scheme was launched, some people had already filed CIRP, but as soon as this PPIRP came into effect, they filed another application for PPIRP. So whether both applications will hold good or what will be the scenario in current date also, what is the scenario? So question is, if application, I've already shared the answer. If application of CIRP is filed during pendency of PPIRP, admission or rejection of PPIRP application would be considered before application for CIRP. So to understand it in a better way, I'm just showing you all the 3-4 questions which are there. If you can clearly see, there is a criteria of 14 days. So let me firstly discuss it verbally and then we will read it out. See, if I have filed an application of CIRP, I'll just stop sharing the screen and probably then we can pay more attention. Suppose I have filed an application for CIRP and within 14 days, I am applying for PPIRP. So this 14 days, within 14 days or after 14 days, that is also a very important element to be checked. If you are filing anything after 14 days, that is irrelevant. If you are filing within 14 days, the matter is different. So this 14 days criteria is to be taken care. But what will happen? What it says is, if you have filed within 14 days, which will prevail? CIRP application will prevail or PPIRP application will prevail? So that is what we have to check. So again, I'm repeating the question. The question is, suppose you have filed CIRP first. Case 1 is when you have filed CIRP first and second application is of PPIRP. There may be other case also when you have filed PPIRP first and now you want to file for CIRP. But the question is whether this was filed within 14 days or after 14 days. So that is how there are three different scenarios, and in which scenario what will prevail, that is what to be seen. It is not that every time PPIRP will prevail. Even if you have filed both the applications, sometimes it happens that CIRP application will overrule the PPIRP. And this has happened in one of the cases in reality. One of the PPI application which has got rejected, the reason was just that two applications were filed, PPIRP and CIRP both. So PPIRP got rejected and CIRP got admitted. So that is the case. So let me just walk you through the slide again. I know this is a bit confusing thing, but see if you can grasp it. So if application of CIRP, okay, is this visible? Well, if the application of CIRP is filed during the pendency of PPIRP, so what does it mean? First, PPIRP was filed. I'm reading question 2. First, PPIRP was filed and then CIRP was filed. So what will happen? Admission or rejection of PPIRP application would be considered before application of CIRP. So ultimately, in short, what happens is, if PPIRP application is filed first and then simultaneously CIRP application is filed, we are not considering the days here. Suppose second CIRP application is filed, then PPIRP will prevail. This is what is mentioned here. Admission or rejection of PPIRP will happen. CIRP will not be considered. If application for CIRP is pending and an application of PPIRP is filed within succeeding 14 days. So second case is different. First you have filed CIRP application and then you are filing PPIRP application. This PPIRP application was filed within 14 days of CIRP application. If that is the case, then in that case, again, CIRP application would be considered. Admission or rejection of CIRP application would be considered before PPIRP. So again, CIRP will hold good. Whatever application is filed first will be taken care first. That is what it says. Next, application for PPIRP has been filed after the expiry of 14 days. So if you are filing an application after 14 days, what will happen? If an application to initiate CIRP under section 7 or 9 of the code have been filed in relation to MSME on the date of commencement of the ordinance, such MSME would not have an option to switch to PPIRP. Like as soon as this ordinance came and you had already filed this CIRP application, only CIRP will prevail. So even if you are not getting this, this will be given to you. You can read it later also. The thing is, we should understand simultaneous applications can be filed. And if simultaneous applications are filed, how adjudicating authority decides which application to be taken care of? So this is up to them to decide, but what rules do they follow? The rule is mentioned here. Fine. So this was the case which was, in which case this particular, what would I say? rejection of PPIRP application was made and CIRP got admitted. This is the particular case, CHD Developers Limited. And in para 29, 30, 31, 37, they have clearly mentioned, and a new section was also introduced for this particular concept, because two applications were filed simultaneously. Which one to be taken care? So section 11A talks about this thing. Section 7, 9 or 10 IBC application filed prior to the ordinance will have precedence over section 54C petition. So Rajkumar sir, you were asking in which section application is filed. It is 54C. As you can see here, 54C is the section where petition for PPIRP is filed, right? Is there any question in the chat box? Sure, sir.
Okay, yes, right.
Okay, next question. Whether the adjudicating authority, while considering application of PPIRP under section 54C of the IBC, can, before admission of the application, hear objectors or interveners? Again, just read it. Whether adjudicating authority has the power, while considering the application of PPIRP under section 54C, can they, before admission or rejection of that, hear the parties? Can they ask persons to come there personally, and they can ask them for personal hearing? Yes, it is allowed. And therefore, the case which we were discussing earlier, they were kept on hold. The objectors or the interveners were asked to come and present their reasoning why they do not want to go for this PPIRP. So adjudicating authority has the power. That is what is dealt in this particular case in the matter of Krish Realtech Private Limited Company. So and so. Adjudicating authority has the right. The appellant had also been given the opportunity to file his rejoinder also and reply to the objections. Hence, he cannot claim that any prejudice was done to him. So it is very much clear. I mean, the applicant cannot say that you are giving more, the NCLT is being partial. It is giving more preference to the objectors. You are not giving me any chance for the personal hearing. It is not that, both are given chance. This is what is dealt in this particular case law. Because here in this particular case, the objectors were home buyers and the allottees, and have paid substantial amount to the appellant, running in lakhs and crores. And therefore, their stake was involved. And if it was only the decision of the corporate debtor to go into the PPIRP, that would not have been fair enough. So that is why the opposite party was also asked to present their thoughts. The appeal was finally dismissed. That is it from my side. Any questions if you want to ask? See, as a participant, you will remember who was the speaker, how was the deliberation, how was the presentation. As a speaker, I would retain who all asked me questions. See, there were so many people, but only Rajkumar sir was asking me questions, or Chetna ma'am was answering. So I will remember just 2-3 names. If you want me to remember you, it's okay to ask questions or any comments or any experience which you want to share.
If permission be granted to me, I can pose one question or some clarification.
First, sir, first.
See, if this is the scenario, like, for the past, like, 2021, not many cases have fallen in this. So this is just out of the thing, like, so what action the government should take to, I mean, strengthen this, section 54, and just to encourage people to, I mean, go for this process. I mean, because the haircut is everywhere. Even if you see the Dure case, like, 5% haircut, like, this company was like, that opened the eyes of all the regulators. So that shouldn't be the fear of like, haircut only the should be the sole criteria for,
That was
I mean,
just
taking the advantage.
one of the reasons I have taken. It is not that government is not of that opinion that haircut. I mean, government should be promoting this. But what is the normal scenario? The normal scenario is that bankers are not ready to accept this process because this is a time taking for them. Because as you can see, that application was filed in 2021 or 22, and that was not accepted in the whole year. Though the time limit they mention is 90 days or 120 days,
Okay.
it's not happening in that way. So rather than waiting so long, they prefer one-time settle. Yes, that is one of the reasons, or that is one of the I can say opinion. But it is not that. So this whole insolvency process will take time to evolve. So as we know, the bigger companies are falling into it. Sooner or later, these MSME will also be taken care here. But simultaneously, we have another platform also, MSME Samadhan. So that is comparatively easier, I would say, and a very strict
Madam, there
monitoring.
also madam, there also the time is taking too much. I mean, and that
Yes,
too,
sir.
like,
Yes, sir.
there are lot many processes are involved. Like, once you get the order, the execution becomes a really a very tedious task. There also, like, this kind of problem is there. And just to be like, very precise, this scheme is to benefit the MSME. And many MSMEs are not in the form of entity. They are all like, you see they work as a
Yes,
feeder to the main
yes,
company.
sir. Individuals are mostly there in this case. Non-corporate forms of business are.
At least, madam, it should raise to the limit of the partnership form, if not individual.
The suggestions are always invited. For your suggestions, but again, the things, the notifications, and all these things are in the minds of LBBI. How do they see it? Because
Yeah.
in every report, annual report is being prepared by IBBI, and this time also they have mentioned it that in PPA-RP there is no much progress. So let's see. We are waiting for the amendments. It's time for the amendments again. In June,
And
normally they do that.
this is with due respect to all, like, regulatory authority. This was just my reading and opinion, just to be like, shared on this kind of platform. It's not like,
Also, we are just discussing it here.
yes.
And yes, someone has asked in the chat box why adjudicating authority admits objections. Will it not delay? Uh, can you just share? Can you just unmute yourself and also ask what is there in your mind? And maybe if you can show us your cute photograph also. Who has asked this question? I'll repeat the question. By adjudicating authority admits objections, will it not delay? See, as a professional, obviously we can say that it will delay, but thinking from the perspective of the other parties, I mean, whosoever has objected, since that in that particular case, which we had discussed just now, the reasoning was very much mentioned that the people who were opposing were home buyers, and their huge amount of money was involved. And just to see that the corporate debtor is not conducting any kind of, or he's not doing any kind of fraud, the perspective of these other of the persons who are objecting should also be taken, should also be considered. So that is why this was accepted. It's not that always they allow people to object, or they always allow them to come forth and speak. But it was specifically here in this case, this was done, and
It
therefore
was
Hmm.
It was not just on an equitable ground that opportunity of being heard should be given to any person who is the intervener.
So when this opportunity of being heard is given,
When you become the party to it, or in the capacity of intervener.
every time adjudicating authority cannot ask the parties to present themselves. No, that is what the question is. Will it not delay? Every time they cannot ask, because see, at the time of filing application, we have already discussed the steps. 66% majority from the unrelated financial creditor has to be there, and then only this application was filed. But it was not mentioned about the operational creditors or other persons. So for them, if their stake is also high, it was this particular bench of NCLT, they allowed them. And this has become a case law for us to study. This might not happen in other cases. I mean, this is just an NCLT decision. Every time a personal hearing is not given, this equality rights will not stand good if the matter has to be conducted in a fair, in a timely manner. Any other question? Chetna ma'am, what is the status of your case? You are on mute. You are on mute. Yeah.
Yeah, I was asking that whether when will we get the certificate of participation in this workshop? Not this is not addressed to you, but to the institute.
So who is the convener?
Yeah. So to this ICAI institute, this triple IC.
Maybe they'll answer, ma'am. Sure.
Yeah, because we have to upload it on the IBDS.
You upload it on the same day.
No, it takes 2-3 months for them to, they don't share the certificate. Then IBBI means without the certificate, we can't upload. That's why because later, yeah.
So I was just asking, ma'am, what is the status of your case? Because you are dealing in front of the.
Yeah, so I have received resolution plan for the case, and means I have issued that final list of resolution applicant, and so there are applicants, but I'm still waiting for the resolution plan, so that there is 1 month to be given, no, to them to prepare the resolution plan. So I'm just waiting. So I was thinking that 29A, because it is SME, it is only thing I will have to check is regarding this willful defaulter and all this basic this and the relationship. Actually they are not means the two resolution applicants, they are not at all related. So what other criteria I have in 29A I should be careful?
Ma'am, on 29A, you have to take care, and then whether the resolution plan provides that the waterfall mechanism is fulfilled or
Yeah.
not. That is the only thing which you have to check, and how they are paying the time limits and all that. Whether it is going to.
And no, and regarding 29A, what other things I should be careful? Like it's not related at all, but what means
Each section is there. You go through it one by one. Check each and every condition.
every condition, right?
Course.
Yeah.
Each condition you will have to check.
And
checklist, in fact, you just do the
Yeah, so regarding this 29A, that whether they have been NPA earlier, that is also one condition, right? So for that, should I ask for credit report of the applicant? What?
You can ask, otherwise you can ask the declarations.
Yeah, declaration they have submitted.
Now you
Yeah.
have to cross verify.
Okay.
That
Yeah.
is what you can do.
But you gave a like very good session it was, and like a few things I got to learn and regarding PPIRP. Actually, PPIRP it is very theoretical. Means because practically we have not come across any.
At pan-India level, there are very few cases. We have
And
just 4 or 5
the
applications.
clients also means people who are distressed. They if they want to go in for PPIRP, the problem is that they have to first settle all the statutory dues and all that. So they take a back seat. Hmm.
So normally, see, ma'am, being a professional, it should be our duty to guide our clients, basically.
Yeah.
But these are the options which are available, which option suits you more. And accordingly, we must find a solution for the client.
Yeah.
So whatever option suits, you can guide them for.
Hmm.
Sometimes awareness is also not there. So accordingly,
Awareness.
you have to take care. So this PPIRP thing, though it has come up in 2021, but it has not gained that much popularity. In the year when it came, that was something, everyone was talking about it. But
Yeah.
it has not given.
Because there are many flaws also because of see a distressed corporate entity would like to avoid giving statutory dues like that.
Yeah.
And statutory claims also whatever we receive, they add interest, penalty, everything. Means it is not the basic tax amount. So it amounts to a large this.
And more or less, sometimes MSME take this as medium to do the fraud also. Sometimes it happens that way. If we are not vigilant enough, the corporate debtor may sometimes take this opportunity to defraud the creditors.
Yes,
So we
yes, yes.
have to be vigilant.
This was the question I was about to ask you. Suppose I have a statutory, creditors, wherein, in the plan, it has been provided as a nil amount. So will that amount to a defrauding creditors, so far as PPIRP is concerned?
Once again, can you please repeat?
See, suppose I have statutory claims in my books, okay, in the CD's book, and at the time of submission of the plan, the value is, say, negligible. So will that amount to defrauding creditors for this application?
So that is what I'm saying for this particular thing. Every time an solvency professional has to be vigilant. Because see, at the time of filing application, we have seen last 2 financial years detail you already have. In fact, you can ask for more. And because liability will be on you whether you have checked the things or not. So insolvency professional has to take care whether the books are prepared in a correct fashion or not.
Suppose I come across and form an opinion that, okay, this application is nothing but to, just to dodge this, the statutory claims. Can I make an appeal on application to the adjudicating authority that this application?
You have to submit a report saying that because we have studied that. No, sir.
Okay.
I have to submit a report about his views.
Okay.
Ashok sir, we can see you as well. Lots of books are there behind you.
Yes, ma'am. Good evening.
Good evening, sir. How are you, sir?
I'm fine. Thank you so much, ma'am.
So you deal in these insolvency cases, sir?
Well, I have, but I have never done any MSME matter. But then today it was very learning experience for me. Thank you so much.
My pleasure, sir.
Yeah.
So would you like to share your experience, because we are here to, understand from each other knowledge. So anything peculiar about your cases which we should also take care in our life?
Well, ma'am, till date I have only handled 2 assignments, and these were not MSME
Then two
accounts. These
assignments. Great, sir. Great. Wow. A huge round of applause for you, sir. You are based
no,
at.
but then you, but ma'am, you know how it works. We are just appointed as IRP, and then eventually the COC changes you. The bank panels are there, and then there are so many other issues on the ground. But I'm mainly into practice on the in the IBC line. I am mainly practice on behalf of the
Based at
CDs.
which place, sir?
I'm from Chandigarh.
Nice to meet you.
Thank you. Thank you.
Anyone else who wants to share his or her experience?
Okay, done. So
We can close the meeting then. Is there anyone from the institute side?
Shall we conclude that?
Yes, yes, please.
Madam, Institute, yeah, I have one request. Hello.
Ma'am,
Yeah, so Madam, when will we get the certificate of participation so that we can upload on the IBBS?
and by 18th.
Hmm?
On 18th.
Okay, thank you. Thank you.
hello.
Thank you very much, Divya ma'am, for such
Hello?
a nice session and giving her time.
हाँ हो गया
Thank you
काम
very
हो गया
much
मेरा
for making the session very interactive.
हैं?
Ma'am, you are requested to share the PPTs also. Divya ma'am, are you here?